Hello everyone, I'm your host Nazarat Fatima. Welcome to Courts Today by Livelaw, where we bring you the latest developments from all courts across the country. To begin with, let's discuss the case titled Rashmi Shukla versus State of Maharashtra. An FIR was registered against the IPS officer Rashmi Shukla at Kolabra police station in Mumbai for allegedly tapping the phones of Shiv Sena leader Sanjay Raut and Nationalist Congress Party leader Eknath Khadse. An FIR was also registered in Pune with regard to tapping the phone of State Congress President Nana Patole. Ms. Shukla sought to quash the FIRs and said in her plea that she was being falsely implicated in the case and that she was a victim of political vendetta. We'll keep you updated regarding the developments in this case. Stay tuned to Livelaw. In a case relating pregnancy out of a physical relationship between a 16-year-old girl and a 22-year-old boy, the Gujarat High Court allowed the petition and gave its nod for the medical termination of pregnancy. The plea was moved by the girl's father, and it stated that if the pregnancy is not terminated, the image of the girl's family will be ruined and it will also affect the marriage prospects of the other girls in the family. Moreover, it was also argued by the counsel for the victim that since the girl is only 16 years old, her lawful guardians were her parents and they could make decisions regarding the termination of her pregnancy. Although the court allowed the termination of pregnancy, it also made an oral remark that her parents should not pressurize her, and if the girl after turning 18 decided to marry the accused, as she would then have the right to make decisions related to her life, they cannot pressurize her to not go for it. In this case, the Supreme Court observed that there are judgments and orders by high courts not deciding cases on the ground that the leading judgment of the apex court is either referred to a larger bench or a review petition relating thereto is pending. It observed that it has come across examples of high courts refusing to follow the judgments of the apex court by reason of a later coordinate bench having doubted its correctness. With regard to the same, the apex court clarified that the high courts cannot refuse to follow its binding judgment on the ground that a reference has been made against it to the larger bench or a review is pending against it. Moreover, the Supreme Court provided clear guidance on the approach that high courts should adopt when deciding cases. The court emphasized that the high courts must proceed to decide matters based on the existing law and should not delay decisions pending the outcome of references or review petitions. It observed that additionally, in situations involving conflicting judgments by benches of equal strength, high courts are instructed to follow the earlier judgment. Most of our viewers must be familiar with the Gyanvapi dispute. To remind the viewers, the ASI, which is the Archaeological Survey of India, is presently conducting a scientific survey of the Gyanvapi complex in Varanasi as per the July 21st order of the Varanasi district judge to determine if the mosque was constructed over a pre-existing structure of a Hindu temple, and the ASI has already surveyed the premises for around 30 days now. The latest update in the case is that the Varanasi district judge today, that is on September 8th, granted the ASI an 8 weeks time period to file its report from the survey. The court passed this order in an application moved by the ASI, which stated that the ASI required more time because there was a lot of trash and debris consisting of garbage, loose soil and building materials, which was dumped on the floor level in cellars as well as around the structure, covering the original features of the structure, and it took the ASI time to clear it. An interesting case came before the Assam State Consumer Disputes Redressal Commission. This is a case where a consumer visited a restaurant in Guwahati in July 2009, where she purchased a sealed bottle of Sprite and noticed a fly inside the bottle while she tried opening the sealed bottle with a bottle opener. The Assam State Consumer Disputes Redressal Commission, presided over by Justice Prasanta Kumar Deka with Mrs. Sonika Bora and Mr. Tapas Kumar Ghosh as members, ruled in favor of the consumer and directed Coca-Cola India Limited to pay compensation of Rs 5,000 to the complainant. In a plea filed by C. Paul Raj against her neighbor P. Anita and other authorities seeking compensation for removing the earth and causing damage to the live teakwood tree by setting fire in Kanyakumari district, the National Green Tribunal has observed that the application is frivolous and has imposed a cost of Rs 10,000 for wasting the time of the tribunal. The court held this while also observing that the vexatious application has been filed even though an order relating this issue was already passed by the appropriate authority. The court also held in this case that such matters are not maintainable before this tribunal, and that moreover the dispute between the parties has already been considered and resolved by the sub-collector, hence the applicant has filed the application unnecessarily to claim compensation. With regard to a petition filed by PC Tiwari relating the ground situation of land sinking in Joshimath and landsliding in Reni and Tapovan, the Uttarakhand High Court has criticized the state authorities for not associating independent experts for studying the landslides and land sinking in Joshimath area of the Uttarakhand. In this petition, directions were sought to the state for an independent committee of experts including hydrologists, geologists, glaciologists, disaster management experts and landslide experts to submit the report assessing the current on-ground situation of land sinking in Joshimath and landsliding in Reni and Tapovan. The court also observed that it infers that the state is not serious about unearthing the real causes for land subsidence and to seriously deal with the situation which has emerged. In addition to this, the bench added that only thorough study would put forth the reasons why land subsidence has taken place, how to deal with the same, and prevent it in the future. The court also, for non-compliance of the order, directed the Chief Secretary, Government of Uttarakhand, to remain present before it on the next date. That would be all for today's episode on Courts Today. If you wish to learn more about these cases, please go to our website, which is www.livelaw.in, and look for the news you're interested in. Keep supporting us by liking and sharing the videos, and of course subscribing to our YouTube channel. Thank you for watching.